Hi, thanks so much for joining us for our webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the incredible William Porter, a California construction lien law guru. Today's webinar topic is a contractors, subcontractors, and suppliers step-by-step guide to getting paid. So without further ado, I'd like to introduce the wonderful and fabulous William Porter.
Wow, Jesse, thank you so much for that very kind introduction. So everyone, we only have 20 minutes today. I'm just going to jump right on into things. And of course, this is all based on California, even though SunRay is a national organization, but we're just going to be talking about the rules for California. Okay, if you have any questions, there should be a chat box on the right, and we'll take questions at the end. I think, Jesse, maybe if they pop up, you might see them before I do, and if that's the case, let me know. There's a little legal disclaimer here. I'm going to go over the general rules, but there are exceptions to these general rules, and there are not too many exceptions, and they're rare. And in any case, a judge at a lower level court can always make their own exception, whether they're right or wrong. So you want to do your best to get this right every time, so you don't end up having to waste time and money in a court arguing over a difference of days or documents or something of that nature. Okay, we're going to discuss four main items here. These are the things that you need to pay attention to so that you can get paid as a contractor, subcontractor, or supplier in the construction industry in California. The first is the preliminary notice. Next is the mechanics lien, then the stop payment notice, and lastly is the payment bond claim. So let's talk about the preliminary notice if we could. So there's some things that you have to address and take care of as soon as you either start supplying materials or you start working. And that is, you have to send out the preliminary notice in many cases. All right, and then I'll just run through these real quick. Maybe some questions will come up, we'll see. Subject to a few exceptions, the preliminary notice is a prerequisite to pursuing either a mechanics lien, a stop payment notice, or a payment bond claim. So if you don't do your preliminary notice right, you're not going to have a viable mechanics lien claim or stop payment notice or payment bond claim. So it's very important. Here's the main rule and the civil code sections. You can look up these civil code sections if you want to read the exact details. You would just maybe go on Google and type in California Civil Code, and you would probably find all of this. Okay, but anyway, if you're a subcontractor or a material supplier, and that's any level of subcontractor, or a material supplier, but generally, if you're a material supplier to another material supplier, then you're probably not going to be able to pursue these remedies. But if you're just a material supplier to a general contractor or a subcontractor or any of those, you should be fine. In any event, you're required to serve a preliminary notice on the owner, the direct contractor, and the construction lender, if there is one, under these code sections. And then if you do it within 20 days of beginning work or supplying materials, you should be fine. Note at the bottom of this page that we're on that direct contractors, that's those who have a contract directly with the owner of the property, they're not required to serve a preliminary notice on the property owner to be able to have a mechanics lien. But if there is a construction lender, then the direct contractor does have to serve the preliminary notice, and they would serve it on the construction lender and might as well serve it on the owner as well. Okay, and then on the timing of these things, as I already mentioned, going down this page, the direct contractors and sub-suppliers have to fill out the form, and SunRay can do this for you, but it's the California preliminary notice. You do it within 20 days after you first furnish labor, materials, or equipment to the job site. You can also send it earlier, let's say going from the date that you have a contract or some kind of agreement where you can say, yes, we have an agreement to do labor or supply materials. Then from that point forward, you can send it out. Just don't go later than 20 days after you start working or supplying materials. You should send it out by, there's different ways, either registered mail, certified mail with the return receipt requested, or you could use express mail or overnight delivery by an express carrier like FedEx or UPS or something like that. Make sure you get it to the correct address of the recipients. Okay, and then before sending out the notice, always make a copy of the fully completed notice for your records. And then by whatever means you send it out, let's say it's a receipt for certified mail or something that you get from FedEx or UPS, you want to staple that to a copy of your preliminary notice so you have your proof later on. If it comes up, could be a year or two later that you'll need the proof. Anyway, you'll have it when it comes up and it'll show that you served the preliminary notice on those persons. Okay, always safeguard the documents. And then again is the code section, which you can look up in the California Civil Code. And as noted, the failure to serve that notice, that preliminary notice, will mean that even though you can go and record a mechanics lien later or serve a stop payment notice or a payment bond claim, it's probably not going to be any good when someone looks under the hood a little bit and checks into your preliminary notice. So don't forget to send out your preliminary notice within 20 days of beginning work, or you can go earlier in order to protect yourself and have these later remedies. Okay, the next subject is the mechanics lien. The mechanics lien is a very valuable tool to contractors, subcontractors, and suppliers who haven't been paid. When you fill that document out, or you have SunRay do it, and you record it, then what it means is that if you ultimately don't get paid, you can sell the piece of property where you did the work, and then you can be paid from the proceeds. There are often issues about priority, like for example, if there's a deed of trust before work began, probably the deed of trust, the bank, the lending institution would probably get paid before you do, but otherwise you would be next in line. Also, if there's a bankruptcy and you're a lien claimant, you're a secured creditor. So you get paid before everybody else except basically the government. So it's a form that you would serve as indicated on the form. You would serve at the county. Well, I'm sorry. You would serve it, yes, indeed, but also you basically have to record it at the county recorder's office in the county where the property is located. If you're in Los Angeles, there are various districts that you have to do it. There's not just one county recorder. And in San Francisco, there are specific rules like putting the APN number on your mechanics lien. Okay, and then remember the mechanics lien gives you as a claimant an interest. It attaches directly to the property where the work was performed. Even if the property is sold, the lien goes along with the sale. So somebody can't cleanse their property of a mechanics lien by selling it. And then ultimately you sell the property, get paid. I'll tell you from experience that it is very rare that the property actually gets sold. Usually what happens is that someone pops up and says, here's your money, okay, thank you very much, and then you would release your mechanics lien. But of course, never release it in exchange for a check because the check could bounce. Only release a mechanics lien once you know that the check has cleared the bank, okay? All right, well, let's talk a little bit about timing. So on this page, you will see two categories. There's either the direct contractor or subs and material suppliers. If you are the direct contractor, meaning you have a contract with the owner of the property, if there is a valid notice of completion on the property or a notice of cessation, if work stops, and it's been recorded at the county recorder in the county where the work was done, okay, then the direct contractor has 60 days after the notice of completion or notice of cessation before they must record their mechanics lien or they will be late. And then I might note this for you, the second paragraph there, a notice of completion is valid only if it's recorded within 15 days after actual completion of the work of improvement. And a notice of cessation can only be recorded after the work of improvement has stopped for a continuous period of 30 days. I mention those because it is very common that people will say, oh, you can't record a lien because there's a notice of completion. Well, I'll tell you this, maybe half of notices of completion that I see are not valid because they were not recorded within 15 days after actual completion. So if someone says, oh, there's a notice of completion, you know, I would, for the most part, I would ignore that because you're not going to know whether it's valid or not at the time you have to record your lien. I'd go record your lien and then figure it out after that. If it turns out that you're late, you can always release the lien. It's not difficult to do. Okay, now for subs and material suppliers, if there is a valid notice of completion under the 15-day rule or a notice of cessation under the 30-day rule that I noted above, then subject to an exception, which I'll note in a moment, subs and suppliers have 30 days after a notice of completion or notice of cessation to record their mechanics lien. So it goes by very quickly, and you have to be careful not to miss that 30-day deadline. There is another rule, because a lot of times there is no notice of completion, or maybe there is one, but it's not valid because it didn't meet the 15-day rule or the 30-day rule we just discussed for notices of cessation. So the rule is this: if there's no valid, timely notice of completion or notice of cessation recorded, then contractors, subcontractors, suppliers, everybody is going to have 90 days after actual completion of the entire work of improvement by all the trades. That's everybody, not just you, but it's every contractor on it. They'll have 90 days after the project is completed before they must record a mechanics lien. So there's some rules here on this page about when is a project completed. How do I know? There's no notice of completion. So you look at these A, B, and C that you see there on the screen, and you pick the earliest of those, and then that becomes the date of completion. And then after the date of completion, under these A, B, C standards, then everybody would have 90 days to record their lien. Now I'm mentioning the 90 days because that's when you're late, but you can always do it ahead of time. In fact, when you're done with your work and there's nothing more that you need to do and they're not paying you, you don't want to get close to that 90 days. You want to probably get the lien recorded earlier, keeping in mind that it will make the owner and maybe the GC very upset that you do this, but you have to protect yourself. So don't rush into it, but give it a little time for you to get paid, but don't miss your 90 days. So figuring out A, B, and C to determine if there is an actual completion. A, if there is actual completion, everything is done, there's nothing left to do. Or you're not so sure. B, you're not so sure if it's done, but the owner or the owner's agent occupies the work of improvement. So it's like a McDonald's restaurant, and they're open for business. Okay, they've occupied the work of improvement, even though there may be something in the back that is not done. You know, maybe their ice cream machine, I guess they're always broken, but you know, something like that. Or C, there's a cessation of labor for a continuous period of 60 days. So the project isn't over, for sure it's not done, but it just stops for 60 days, often when someone runs out of money. Anyway, you look at that A, B, and C, you pick the earliest of those, if maybe there's two of them that apply. You pick the earliest, and that will be your date of completion, and then you will have 90 days to record your lien. Of course, remember, this is a substitute for a valid notice of completion or notice of cessation. Okay, let's see here. The procedure to record your mechanics lien. It's not a difficult thing, but what you do is you fill out the form, or you have SunRay do it, and you take it to the county recorder in the county where the property is located. And there's going to be a filing fee, there may be a notice of completion or notice of cessation on file. You might not be aware of it because you weren't sent it. So that is something that you have to be cautious of. You may never know that there's some rules to protect you about this, but for the purpose of this, I would not get close to the deadline. Okay, it's better to record a mechanics lien sooner than miss your 30 or 60-day deadline that we discussed a little bit earlier. Anyway, though, you take it to the county recorder in the county where the property is located. I know that, for example, in LA, they have multiple county recorders because it's such a large county, and you have to use the correct one. So you might have to research that a bit. Okay, and then for San Francisco, always put the APN number on there. I noticed that they have a problem with that. Even though it's not part of the law, they kind of do their own thing in San Francisco, and that's what they do. All right, okay. Then after you have a mechanics lien, the next step of it, you have to file a lawsuit. So as noted on this page, you're going to have 90 days to file a lawsuit on the mechanics lien. It's a straight 90 days. There's no if this, then that. It's just you record a lien. You'll look at the date on the upper right of the lien form that the county puts on there, and then you have 90 days to file your lawsuit. All right. If it's on a weekend or a holiday, you would go to the next business day at the county recorder's office. But shoot, don't take it to the 90th day, right to the 90th day. You don't have to. You could file it right off the bat. and you would probably use an attorney for it at this point. But what you should do after you record it, let the other side know, hey, we're not going to miss our 90 days here, so let's get this resolved, and see if you can get it resolved before you have to go to an attorney and start paying money. Okay, there's no right to attorney fees on a mechanics lien loan. If you have a right to attorney fees, it's going to be under a particular statute, or it'll be in your contract. So you don't want to be wasting money on attorneys if you can avoid it. All right, so do what you can to resolve it, but don't miss your 90-day deadline for filing a lawsuit to foreclose on your lien. And in the same lawsuit, you will be bringing claims for breach of contract and all the other possible claims that you could have against the party who didn't pay you. One of the nice things about pursuing a mechanics lien as a subcontractor or a supplier is you don't have a contract with the owner, and you would have no right against the owner if it was not for the mechanics lien. So you suing on the mechanics lien makes you jump right over the contractor, subcontractor, and go against the owner, and the owner will put tremendous pressure on the general contractor, who will put pressure on subcontractors, etc. Anyway, though, it's a wonderful remedy, particularly for subs and suppliers. Okay, it puts a lot of pressure into the system to get you paid. Okay, then the next thing, a remedy, remember I said there's three: mechanics lien, stop payment notice, and payment bond claim. Okay, so what a stop payment notice is, it causes either a bank or the owner of the property to withhold money when you send them a stop payment notice. So you'll fill out a form, or you'll have SunRay do it, you will send it to them, and it's basically your time periods for doing that are the same as a mechanics lien, which we already discussed, but the code sections are there if you would like to review them. And note, you can use the stop payment notice along with the mechanics lien and the payment bond claim if there is a payment bond. Okay, so these are all complementary things. They're not mutually exclusive. You can do all of them. If you think of it, look, if you messed up on the mechanics lien for some reason, maybe you can have success on the stop payment notice or the payment bond claim. Ultimately, though, in the end, you're not going to collect 3 times if you get them all right. It'll be worked out, so you'll get what you're owed, but you've got to follow the rules. All right. I should note that if the stop payment notice that you serve is on a private project, okay, and there's a construction lender, if you don't get a bond for the stop payment notice on a private project, then the construction lender is going to ignore your stop payment notice, and they will not withhold the money. Okay, so go out to a company and say, I need a bond for a stop payment notice. And then if they do that kind of bonding, they'll know what to do. Okay, and then when you do a bonded stop payment notice, because there's a lender, then they will withhold the money. They'll withhold 125% of the amount of your stop payment notice. And then if there is no lender, though, you serve it on the owner of the private project. And you don't have to use a bonded stop payment notice, which is great. Okay, anyway, you serve that. Later on, you have to file a lawsuit. Here's the procedure to give a stop payment notice. You fill out the form or have SunRay do it. You give it to the owner or the owner's architect and the construction lender, if there is one. You can use personal service. On all these things, you can use personal service, but don't do it because you can't prove it very easily. So I would use express mail, registered mail, certified mail, that type of thing, okay? And when you're serving the construction lender, if there is one, you're required to serve the manager or other responsible officer or person at the branch of the lender where the funds are actually being held. So like if it's B of A, you don't send it to their world headquarters, you send it to the officer or person at the branch of the lender where the funds are being held. Okay, procedures for serving a stop payment notice. If there's a valid notice of completion or notice of cessation, which we've already talked about which ones are valid earlier on, then a sub or supplier is only going to have 30 days from the date that of the notice of completion or cessation before the stop payment notice must be served. And then noted earlier, notices of completion are only good if they're within 15 days of actual completion, and notices of cessation are only good if they're recorded within after a continuous period of no work on the project for 30 days. Okay, so just don't get close to the deadline. Once you're done with your work, you're open to be able to do these things. All right. If there's no valid notice of completion or cessation, again, A, B, and C here, this is how you're going to figure out when completion is. You're going to pick the earliest of those. We already went over that, and in the interest of time, I'm going to move on. And then you would pick a day for completion, which would be 90 days after the earliest of those. Okay, there's a lawsuit deadline. You can do it with any time within 10 days, but not later than 90 days following the expiration of time within which stop payment notices have to be served. Generally, that would be either 180 days from the date of completion, or if there's a notice of completion, 120 days from a notice of completion, from a valid one. So if you have a mechanics lien, a stop payment notice, or a payment bond claim, and you say do your lawsuit within 90 days, you won't miss the deadline for any one of these remedies that we're discussing today. Okay, because the mechanics lien lawsuit deadline is the shortest, which is 90 days. Once you have done served any of these things, a stop payment notice, a mechanics lien, or a payment bond claim, calendar out 90 days later to file your lawsuit. Calendar out to talk to your attorney a little bit before that. Okay, then the next and final topic we're going to discuss is the payment bond claim. Now, a payment bond is not always on a private works project, but it is almost always on a public works project. So if you're doing public works, there's going to be a payment bond almost always. All right. So if you're going to make a claim on the payment bond, then you have to serve it within 15 days of a notice of completion. Well, actually, this is a special remedy, but I would say that is a good rule to follow. If there's a remedy that says, let's say you didn't do a preliminary notice like you should have, then you should serve a payment bond notice within 15 days of a notice of completion. And if there is no notice of completion or notice of cessation, then you have 75 days from the date of completion, actual completion, to serve your payment bond notice. In many cases, the notice isn't even required. You can go straight to the lawsuit. But I would say the best practice is, once there's completion, within 15 days, serve a payment bond claim on the payment bond surety. Okay, you would serve it on the bond principal, which is usually the direct contractor, and on the surety, which is the bond company, by all the means we talked about before. But I would say certified mail return receipt requested is probably best, but you can use UPS and other overnight delivery services. Then you're going to have to file a lawsuit. All these things, you have to file a lawsuit to bring it to the next step. But the lawsuit on the payment bond surety has to be filed within 6 months after completion of the work. So it's the longest deadline. Again, I would say that if you did a mechanics lien, a stop payment notice, or a payment bond claim, you will never miss a deadline if you calendar out to file your lawsuit within 90 days after you do any one of those things. You'll never miss a deadline. Let me add this. Don't come and see your attorney on the 89th day and say, oh, I have to file a lawsuit tomorrow. You know, give your attorney like at least 10 days notice, and you'll have to give them various papers. They will bring an action for breach of contract on the mechanics lien, on the stop payment notice, on the payment bond claim, and various other claims like the reasonable value of your services, quantum merit, things like that. They all have to be brought in one lawsuit. Okay, there we go. I was a little over. My apologies for that, but it's a long day.
No need to apologize. You did incredible, Bill.
A lot of info in there.
Right. Yes, you did. You crammed it completely full with little tidbits of information and knowledge for everybody. So thank you so much. We do have a couple of questions that came through. The first one that says, if I am a GC, I am not required to send a preliminary notice, but if there's a lender on my project, can you hear me any better now?
It breaks up, I think. Can you hear me?
Bill, can you?
I
can hear you perfectly.
Okay, so the question was, hey, I'm a GC. I don't have to, is it correct that I don't have to serve a preliminary notice unless there's a lender? And that is true. If there's a lender, then you do have to serve a preliminary notice on the lender. That's true.
Okay, perfect. Thank you so much for that.
Yeah.
Okay, and then are there any exceptions that would extend the 20-day period to send the preliminary notice?
Well, not really, but I will add this. It's kind of an exception. Let's say that you forgot to do the preliminary notice within 20 days, but then you did it within 30 days, so you were 10 days late. So the way it would work is on the day you put the preliminary notice in the mail, even though it's late, the the effect of it would go back 20 days. So you wouldn't be able to make a claim for whatever you brought to the project in the first 10 days. So, but think of this though, if it's a rather longer project, not just a one-day kind of a deal, but a longer project, it's probable that you're going to get paid for those first 10 days. And the fact that you were 10 days late won't matter by the end of the project, because usually what happens in larger projects is that people do get paid early on in the project, and then things go wrong and issues develop, and it's towards the end of the project when people start not getting paid. And at that point, you will already have been paid for that first 10 days. So the exception is if you're late, it's still valid, but the date of its effect only goes back in time 20 days from the date you put it in the mail. And then if you have a lien later on, you would get, and let's say it covered the whole project, you just wouldn't be able to make a claim for the first 10 days. But you know what? I have seen this mistake made many times, and honestly, the people on the other side don't even realize, you know, the basic rules. So it could go either way. Just don't be late. If you're late, it goes backwards in time 20 days from when you put it in the mail, its effect does, and hopefully that'll keep you in good shape. So that's kind of an exception. Otherwise, I'm not aware of any exceptions.
All right, perfect. Okay, another question that has come through, it says, who is required to send the notice of completion? And then it says, for a GC, what is the benefit to record the notice of completion? And if you don't, then you have 90 days.
Yeah, so I would say this.
To file your lien.
Yeah, you broke up a little bit, but I think I understand. So typically it is the owner that files the notice of completion. But I have seen many times that the GC files a notice of completion as the agent for the owner. Okay, and the reason for doing that is it accelerates all the time for everybody to send their mechanics lien stop payment notice or payment bond claim. Because remember, if you do it properly, and then you have to actually serve the notice of completion on people, it's just a different rule. I would serve people who sent a preliminary notice, but also it is something that you can use with the owner and say, hey, look, I have sent out a notice of completion to everybody, and they've all received it. I got their return receipts. So if nobody's recorded a lien in 30 days, then we're free and clear. Otherwise, you're going to have to wait 90 days, and the owner isn't going to want to pay you until 90 days have gone by. So it accelerates you getting paid. And it also causes people that could put a lien on the property or send a stop payment notice to fail to do so because they had 30 days and they're just busy and they didn't get to it, and it kind of crept up on them. So it gets you paid quicker, and it makes subs and suppliers make mistakes.
Okay, perfect. Thank you so much for that explanation. That does seem to be all the questions that have come through. If anyone does think of a question that wasn't addressed, please feel free to reach out and we'll be sure to answer them. Bill, can you go to the next slide for me, please?
Oh, yeah. Here we go.
Okay, so here are some of SunRay's resources to help you stay organized, know your deadlines, and secure your lien rights. So go ahead and scan that QR code to access these incredible resources. Next slide, please. All right, our next webinars with Bill, they're going to be May 15th, what happens after I record my lien and how do I get paid? And then the next one is August 14th, statutory construction releases, which to use, how to use, and when to use. Please sign up for free at sunraynotice.com/education. We'd love to see you guys there. I believe later in the year, we even have a live in-person seminar that we'll be starting to get everything ready for. So that will be really excited to get to see you all in person. And then the next slide for us, please. All right, if you don't mind, take a moment to give us a review on Google. We really appreciate it. It only takes about a minute of your time, but it helps us with some of the feedback and bettering our webinars and the content that we offer. And then the next slide.
Jesse, on that live seminar, I hope we get that all pulled together and put a date. But that one is really detailed. I'm going to be going on for like 2
Absolutely.
hours. And we'll
Yep.
talk about all this stuff in a 2-hour period of time, plus many other things that relate to this, including prompt payment remedies, federal projects, and this type of thing.
Yep, it will be a really, really great, wonderful day of getting to get some information from you guys and from you, Bill. I really appreciate it. With that, that is all we have for you guys today. Thank you so much to everyone that attended. We hope to see you at our next webinar. Bill, you really are incredible. So thank you so much. I hope you all have a beautiful and wonderful sunny day. Thanks, everyone.